Bill Sorrell, the Attorney General of the state of Vermont.
I am.
Yes. How do you do? I'm Paki Wieland. I'm one of the shut-it-down defendants who's been arrested up in your fine state.
Oh, and, did we treat you well?
You've treated us very well. You wouldn't allow us to go to jail, though. You insisted that we pay a fine.
Oh, well, don't take it personally.
But, no, actually, I'm very impressed with the state of Vermont that you don't take money, but rather have people keep their jobs and do community service. So as a rule, I think it's good. I didn't like it personally, but it was really a pleasure watching what took place this morning, and it's really heartening. I'm doing this for our local cable television in Northampton.
Okay.
Are there any comments that you haven't had a chance to make that you would?
No, I think I've pretty much covered it. Obviously, we took it very seriously, worked very hard as a team. We went through a number of so-called moot courts of, fake or practice courts leading up to today, and I think all that preparation, hard work was reflected by what we saw in the courtroom today, an oral argument, and obviously the written arguments.
Okay, so you were our hired gun. All of us who want that nuclear power plant closed down. I'm not doing that. This is actually for our local cable television in Northampton, Massachusetts, and I just want to thank you for the wonderful presentation you did.
It's my honor to do that.
And could you give me your name?
David Frederick.
David Frederick. And David, what made you choose this? I mean, I know it was a lucrative payment you got, but what made you decide you would take us on?
Well, we did it at a discount. We took this matter on at a discount for our normal rate, so I do want that point to be known. I do a lot of representations of different states on different matters of public importance that where a need for private counsel is present, and I was honored to be asked to work on this case.
Yeah, we did a wonderful job. Thank you very much.
What sort of precedent would this set? What would this mean for the future of such issues?
I think the difficulty is that his methodology is so flawed that it would create real problems for state legislators. They would not know what they can say or not say with respect to matters that are clearly within the realm of their prerogatives and their authority. And that's one of the main problems with his opinion, that you look at statements that were made in committee hearings well before the final bill was enacted, and then you disregard what the final bill says.
That's why we got so many states to, through the National Conference of State Legislatures, to write a brief supporting us, because quite apart from the issues of nuclear power, what Judge Murtha did here could have a chilling effect on the traditional freedom of legislative debate. I mean, it's in the legislative halls where you want discussion and debate, and if every time the legislature's thinking about an issue of constitutional dimension, whether it's civil rights, gay rights, freedom of speech issues, or federal preemption issues, if the legislators have to keep quiet and not say anything for fear that down the road some comment is going to, by a handful of legislators, is perceived to be speaking for all 180 legislators, that's just a distortion, and it would be a real shame if we got to a situation where legislators were reluctant to speak their mind on important public policy issues.
And so what's next? Where do you go from here? This was an expedited schedule, but not necessarily an expedited decision, correct?
That's at any time you're dealing with the Court of Appeals, they have their own timetable. It's obviously a very complex matter. They recognize the complexity of it, and we just wait. That's what we do next. We just wait for a decision.
What do you think the chances are of this going to a rehearing or going to a 9-judge panel, or what do you see as the trajectory of this case?
This court traditionally has not reheard cases en banc, but obviously it's a high-stakes case, and we'll just wait to see what they do.
And Mr. Sorrell, just a question about Mr. Frederick. Why go to outside counsel this time? Why not stick with lawyers in Vermont?
I've got some hugely smart and accomplished lawyers that we've had working close to 24/7 on this case since it was filed. But here we are at the Second Circuit. It's a different league, and we wanted to fight fire with fire, and we went out and hired a guy who's nationally known and respected as among the best appellate litigants in the country. And I'm really proud of what David did for Vermont today.
Do you think that the investment made a difference this time around?
Well, we'll see what the decision is, but I have had no second thoughts about hiring David and his firm to be of assistance to us.
With so many other nuclear plants in other states, do you feel that the state of Vermont is sort of carrying the water here for what other states may be going through as they try to regulate these power plants?
Oh, I don't think there's any question but that folks all over this country are looking at this case as we look at the future of nuclear power in the country, both in terms of relicensing of existing plants and then whether new plants are going to be authorized, and what are the legitimate state roles in deciding whether to allow a plant to operate initially, and then, as David argued today, that there's no real difference between the relicensing decision and the initial decision, that you don't have a leg up as a nuclear power plant to be able to continue operating after your useful life of your initial license. And that's what we argued, and all kinds of states are interested in this case for those and other reasons.
Did you raise the issue about the state being on the hook for cleanup costs, reverting back to greenfields at trial? Was that?
Oh, sure, we argued that, and you know, among the other things that we talked about, David mentioned it a couple times today, was this Entergy proposal to shift Vermont Yankee and a few of its other plants into this other shell corporation. And in a very bipartisan way, the state Senate, a lot of folks who I think in the state Senate are maybe not against nuclear power, saw this as an attempt to get out from under liability and to shift responsibility to the state. And I thought among our arguments today that were really strong upstairs was this fact that even if we're not buying 1 watt of power from Vermont Yankee, we have a real interest financially in that plant, and the very real fact that we might end up holding the bag for millions and millions of dollars when it's no longer operating.
What did you make of the court's interest in that question or other questions? Did you think that they were at all leaning or receptive to your arguments?
Bottom line was, and David can speak to it, but there were more questions today that I was pleased to hear than ones that made me cringe.
If you were to lose at this level with the 3-judge panel, is it an automatic that you seek a hearing before all 9?
Well, the Attorney General will make that decision. We'll wait to see.
After consultation with counsel. If we get there.
And it depends on what they say.
It does.
There are so many variables at this point, it's impossible to make a judgment about that in advance.
Can you say anything about this panel, their history, with regards to similar issues?
Not really. It's a relatively new panel of judges. They were very well prepared. They had worked very hard, and they asked very good questions. And it was a pleasure to appear before them. It was also an honor for me to represent the state of Vermont, and I appreciated that very much.
You did a good job.
Thank you all very much.
How many states joined as Friends of the Court?
I'm sorry?
How many states joined as Friends of the Court?
What the talent.
9.
Remember?
Excuse me. Hi.
How many states were on the New York's brief?
Yes. And I'm based in New York, so I'm a bit new.
9.
So I apologize if this is
9 other states, not
Yeah. And then we had a number of environmental groups, and we had the NCSL. And the important thing about that was that represents all 50 states, red, blue, and otherwise. And they wrote a very good brief.
So there's a process for dealing with the radioactive materials.
This case is a real consequence for those reasons.
The federal government doesn't step in and fund.
So it's great for us to get NCSL in. So it's not just this liberal Vermont fighting the nuclear power industry. This is an important case for states all over the political map.
You were quoted earlier in press clips to outside counsel at that time.
Yeah. And just so you know, a couple 100,000. But, you know, I mean, there are 2 issues in the case, and that one on the dormant commerce clause. not saying this would be great by any stretch, but one of the judges was very skeptical about the injunction, and if we prevail on that, then our liability to pay attorney's fees goes out the window, because that's the constitutional dimension for attorney's fees. So that that's a multi-million-dollar issue, quite apart from the outcome of whether the legislation is upheld or not. So we had a number of reasons to be here at the Second Circuit, and obviously, if we prevail on, we want to win outright. But prevail there, it's a good day at the office, and Payne David's firm is going to be one of my better financial decisions as Attorney General.
And Kathleen Sullivan, any idea what her bill is looking like?
Their bill, I think, was $4-point-something million just through the trial. So
a lot higher than ours.
So I mean, I don't know what it is through this point, but not cheap.
And I'm sorry, I just was coming over. I just wanted to confirm the number on outside counsel was about $250,000.
Yeah, that was what it was, and I don't know what the current bills are now, but money well spent. Trust me.
Thank you very much.
Thank you.